Good morning, ladies and gentlemen. I'm pleased to see you here for the second day of our conference. And for those of you that were also here yesterday, I hope you've recovered well and enjoyed yesterday evening's dinner, yesterday evening's quiz, yesterday evening's music, and above all, yesterday evening's dancing. I myself personally enjoyed the dancing very much. Now, I'd like to just start off by reiterating the aim I put forward yesterday in my opening comments for this conference. A twofold aim, if you remember. First of all, I think clear for all of us, to share ideas and views in a concrete way in how we can enhance consumer protection policy in today's digital era. But the second aim has one eye also on a different future, the fact that the European Consumer Summit is also upcoming, and this is an opportunity to provide concrete inputs for that summit too. So, linking with that aim then, what did we achieve yesterday? Well, I think through our two phases yesterday, our interventions from the Minister, the Commissioner, and also a member of the European Parliament, and then the panel discussion that followed on consumer challenges in a dynamic environment, I think we made good progress together towards that aim. And I'm sure we can continue to do that today. Now, what's on today's agenda? Well, just to remind you, we've got 4 phases, 4 of our 6 total phases today. We're going to start off, as we all know, with a panel discussion here on priority setting in consumer policy. And I'm sure, as yesterday with the panel discussion, we will have a lot of active participation through the questions from our audience. I'd like to remind you, you find on your seat a sheet where you can write down a question and send to me to pose to the panel. Our hashtag that you see on the slide here, you can tweet your question if you are more digitally minded in that sense. And my colleagues will share that with me to give to the panel. Or in the more traditional manner, you can, of course, raise a hand to ask a question, which I'll also pose to the panel. Now, after this panel discussion, we'll then take a short break. And to take us up to lunchtime, we have 3 parallel breakout sessions. Now, later on, I'll let you all know specifically the meeting points for those sessions and the rooms for those sessions. But now, I'd just like to note the titles for those. The first session is Challenging for Enforcing Product Safety in the Digital Era. The second, Problematic Consumer Markets and the Way Forward, Making More Effective Enforcement and Redress. And the third session, Consumer Confidence and Empowerment. So, after those 3 sessions, naturally, we'll all come back together in this room. And the chairs of each of those 3 sessions, the moderators of each session, will then do a short summary for all of you of the main outputs from their session, so that everybody, although attending only one session, will receive the value from all 3. We'll then close off our day with myself giving a brief summary of the main outputs of the conference, and then a few words from a representative on the Latvian side. And then we have a light lunch for you, a buffet outside, just to close the event and send you all away with a comfortably full stomach. Now, without further ado, I think we should get straight down to business with our panel to make sure we've got as much time as possible for your questions after. So I'd like to introduce very briefly the panel to you and then hand over to them. So from my right here, we have Rieko Tamefuji from the OECD. We have Bernadette van Buchem from the Netherlands. Teresa Moreira from Portugal. Biba Vitolina from here in Latvia, and Martin Seeker, again from the Netherlands. So without further ado, I'd like to hand the floor to Rieko.
Good morning, everyone. My name is Rieko Tamefuji. I'm working as a consumer policy analyst at OECD as one of the secretariat to the OECD Committee on Consumer Policy. So thank you for inviting OECD to this event. I would also like to take this opportunity to thank the European countries and the European Commission to their great contribution to the OECD's work. So today I would like to talk about the consumer policy toolkit. Okay, here's the outline for my presentation today. So I would first like to take a few minutes to talk about OECD Committee on Consumer Policy, and then I will move on to talk about the toolkit. So first about the OECD. So the OECD currently has 34 member countries. This includes 21 EU members. And we also have accession countries, which is in the process of becoming member countries of the OECD. We have Latvia, Colombia, and I have to add here Costa Rica and Lithuania right now. Those two countries just become accession countries from the middle of this month. Okay. And I would like to briefly talk about what OECD Committee on Consumer Policy is doing. And we also have under this committee, we also have working party on consumer product safety. And within the CCP, we have 3 key work streams. The first one is the e-commerce. So the biggest project in the CCP right now is the revision of the 99 e-commerce recommendation. So it has not been revised since 1999, but it's actually still really robust. But we are now trying to take into account and make sure that it will work for new types of e-commerce that have recently happened, like mobile commerce, digital content, for example. So the second work stream is consumer economics. This is what I'm going to talk about it today, so I'm not going to talk about it right now. And the third work stream is the product safety. We have a quite long list of projects in this area. I just named a few here. We have global Rieko portal. We do public awareness raising campaign. And currently we are working on a project on online product safety, which is of course related to e-commerce. So we are now trying to identify what kind of unsafe products are sold in the e-commerce market. And we are actually going to do an internet sweep on this issue next week. So turning to the Consumer Policy Toolkit. The Consumer Policy Toolkit was published in June 2010, and since then it has been used by many OECD members and also amongst the non-member countries. So based on this, I would like to remind that we have also developed a recommendation of the Council on Consumer Policy Decision Making, which is really based on the toolkit in 2014, last year. So what we have in the toolkit. I would like to start by talking about why we need consumer policy toolkit. So I have to admit that looking at the policy tools that is explained in the toolkit, most of them are what all consumer policy makers and enforcers are already familiar with. But I believe before toolkit, there has not been formally articulated before. So the toolkit aims to provide a solid framework for consumer policy making. We think that there are mainly 2 reasons why we think we need a policy toolkit now. And the first reason is that given the complexity and challenges the market are facing, the need to formulate a clear framework has become more significant than before. So what kind of challenges am I talking about? So for example, we now face increasingly complex products, such as like digital content, Internet of Things, and so on. And we are also facing rapid technological change. Actually, the new technologies are being adopted faster by consumers these days. The second reason is that there are areas that have been developed recently and has not been taken into account clearly in the past. So the Consumer Policy Toolkit also aims to introduce those kind of concepts to the consumer policy making process. So behavioral economics is it's one of the examples, and I will talk about it in detail later. Okay. So as I mentioned, Consumer Policy Toolkit aims to provide framework for policy decision-making process, and this is described as 6 steps for dealing with consumer problems in the toolkit. So the first step is to identify the problem, second step is to measure the problem, step 3 is to determine whether we actually need to take policy action, and step 4 is to think about what kind of policy options we have, and step 5 is to determine which policy to take from those options. And the final step is to review and evaluate the policy actions implemented. I do not have enough time to go through in detail of these 6 steps, so I would like to mention mainly about step 1, step 3, and step 4 today. So starting from step one, so consumer problems have to be identified by using proper tools. I think this would be also important in terms of when identifying the priorities. I have listed tools authorities can use to identify problems. There are proactive measures like research. There are also reactive measures like consumer complaints. And I have also noted indicators here which are notably developed in the European countries, including the Consumer Market Scoreboard by the European Commission. Although I listed many here, actually there is a strong reliance on using consumer complaints to identify problems in many jurisdictions. So of course, consumer complaints are very useful, but we think that we also need to keep in mind its limitation. So for example, complaints are by definition, it's based on consumers' perceptions, so we don't know it's actually true or not. It may be seriously flawed. Another limitation would be like there are only problems that could be identified by consumers and reported. So if the consumers are unaware of the problem, that's not reported. For example, if the businesses intentionally hide better options from consumers, and consumers are not aware of the fact that they're not doing the best choice, that kind of things cannot be presented in the complaints. So in addition to the tools just mentioned in the previous slide, I would like to mention that jurisdictions are increasingly taking into account behavior economics when identifying problems. So behavior economics describes how people fail to behave in their own interest, which will not happen in the conventional economic theory. There are many behavior biases that will be useful when thinking about consumer policy. I listed a few here. This includes a rule of thumb when dealing with complex decisions, endowment effect. Consumers usually value things they own, means they prefer status quo, and anchoring effect, which consumers anchor to the piece of information they think is the most important. And these theories are increasingly used by jurisdictions for policy making and the enforcement actions recently. One example, as you may all know, is the EU Consumer Rights Directive, which prohibits predict airline optional costs. This could be rationalized by default bias. And also, drip pricing has been a problem in many countries. Drip pricing is where additional costs are revealed only through the retail process, meaning that it is not shown in the headline price. This could be problematic and could be explained by theories like endowment effect and anchoring effect. So there are enforcement on drip pricing recently by many jurisdictions, including United Kingdom, Australia, and Canada, and so on. For example, on airline companies. So far, I talked about identifying the problems. So after identifying the problems, we need to determine whether we actually need to take actions. So the question listed here is what we should think when thinking about this question. The questions would include what is the scale of the consumer detriment, who is experiencing the consumer detriment, and we should also think about the anticipated duration of the consumer detriment. Is it going to increase or decrease or remain or things like that? And we should also think about the likely consequences of taking no policy action as well. And finally, we should not forget about the other substantial costs in the economy. So the consumer, if there is a consumer detriment, it's not only the consumers who suffer, the businesses might suffer as well. For example, if the reputation of the industry as a whole suffers from one bad company, the legitimate firm also may experience lower sales. We should take into account of those problems as well. So once we decided to take actions, we need to think about the policy tools. In the consumer policy toolkit, there are 12 policy options presented. These are divided into two groups. There are demand-side measures, including education and giving more information to consumers, which basically means would enhance consumer empowerment. The other group is the supply-side measures, which is, I would say, like more conventional policy measures like licensing, enforcement, prohibitions, and so on, which is aimed to correct business behavior. Lastly, I would like to mention about a few examples of how the toolkit is being used in reality. So in the OECD, we did a toolkit workshop, and we examined how the 6 steps in the toolkit has been dealt in communication service sector. So by using the policy framework, we identified problems like, for example, when detecting the problems, there was a heavy reliance on consumer complaints. And in Australia, the Australian government published a companion to the toolkit in 2011 that shows how principles and ideas in the toolkit could be applied in an Australian context. Another example comes from Canada, where Industry Canada published the Consumer Impact Assessment. This guide encourages analysts to use a combination of traditional and emerging analytical approaches when assessing consumer impacts. This includes behavior biases, which are addressed in the toolkit. Another example comes from Canada. It's the consumer lens. So the Canadian Radio, Television and Telecommunications Commission developed a one-page template, the consumer lens, for commission staff to identify and assess consumer impact, which is directly based on the toolkit. It is not on the slide, but I would also like to mention that in the revision of the OECD 99 e-commerce guidelines, concepts presented in the toolkit are used as well. For example, we are considering including provisions regarding drip pricing, which, as I mentioned, is based on the toolkit. So today, I only talked about toolkit, but as I mentioned earlier, there's many projects going on in OECD. So OECD appreciates your contribution, and we're also looking for our future collaboration. Thank you very much.
Thank you, Rieko. I'm sure we're all pleased to hear there about the OECD's work streams, particularly the toolkit and those 6 different steps for dealing with problems, also including identification, the rationale for action, and the policy options. Now, I'd like to hand over now to Bernadette. The floor is yours.
Thank you, David. Good morning, ladies and gentlemen, dear colleagues. Let me begin by thanking our Latvian hosts and my dear colleague, Mrs. Baiba Vitalinia, for inviting us here to share experiences at this panel discussion about priority setting and consumer policy. I'm delighted to have the opportunity, as fellow EU authority, to share with you our methodology of priority setting in enforcement of consumer protection and sharing our ways of analyzing emerging trends. And to make a connection with the OECD toolkit, I will tell you more about how we take care of the first 3 steps of priority setting. In my speech, I will briefly present myself and tell you a little more about my organization, the Netherlands Authority for Consumers and Markets. Then I will elaborate on today's topic of prioritization and share with you my experiences and points for improvement. I will conclude this contribution with some final comments. Let's see if it works. Yes. For those who don't know me, my name is Bernadette from Buchem, and I have been director of the Consumer Division of the Netherlands Authority for Consumers and Markets since its launch on April the 1st, 2013. ACM was established through the merger of the Consumer Authority, the Independent Post and Telecom Communication Authority, and the Competition Authority. Before the merger, I was the director of the Consumer Authority. With the establishment of ACM, consumer protection, sector-specific regulation, and competition oversight were all placed in one single authority, located in The Hague. An important reason for the merger was financial saving in order to meet imposed budget cuts. But there were more reasons, such as creating more synergies between the various enforcement tasks, and therefore achieving more efficiency and effectiveness in the performance of tasks. Currently, our authority has 500 employees and is managed by a 3-member executive board. Of course, after 2 years, there are a lot of interesting issues to reflect upon in relation to the merger. Let me give one example. Within the consumer side, there was some worry that after the merger, consumer protection would become less important than competition enforcement. However, the reality today is different. Consumer issues seem to have a much stronger impact on ACM's profile than many people expected before the merger took place. Therefore, consumer issues are very much of strategic importance for the authority. This is also to do with the political and media appeal, the concrete nature and number of consumer cases. In addition, I should say that no major shifts in resources within the authority have taken place between competition regulation and consumer protection. Moving to today's theme of prioritization. One of the issues we have been dealing with since the launch of ACM is the issue of focus. In the beginning, the question was, how do we create the right focus in the authority's work? And nowadays, the question is, how do we maintain that focus? When we merged in 2013, one of the priorities was to create a single strategy for the authority. So we went through all our norms and policies and came up with a single set of principles and policies which unite us. Our mission is to promote opportunities and options for businesses and consumers. We create opportunities by fighting unfair competition and by making it easier for new competitors to enter markets. Such opportunities stimulate innovation, new products, services, and businesses. And we create options, because having options is the key for having functioning markets. We want consumers to have a real choice, and that's why we want businesses to be clear about what they offer, and consumers should be informed at what their rights are and able to act accordingly. Consumers are central to our oversight philosophy, and this central position of consumers will also be reflected in our prioritization policy. ACM has one set of combined priorities for competition, regulation, and the protection of consumer rights in the non-financial industries. In order to define these priorities, we have designed a working process containing a planning cycle and a working plan. I will not bother you with too many details, but crucial in this working process is the detection of the most important problems in the markets and the prioritization of them in a 2-yearly agenda. In order to be able to prioritize, we need to be sure that we are aware of the most prominent consumer and market issues out there, as well as their size and nature. In order to be able to identify them in good time, we invested substantially in expanding our intelligence capacity. In setting up this capacity, we ask ourselves questions such as, how do we identify the most important problems in the market? How do we know the general trends and relevant developments in markets? And external orientation with this is crucial for ACM. How do we find what is happening in the markets? Firstly, we have dedicated staff and teams for intelligence work. Within each division, the so-called ACM radar. These people work closely together with their counterparts in other divisions. We identify potential market and consumer problems through intelligence, through the organization's own efforts, like intelligence from Consuwijze. Consuwijze is our consumer portal and information desk. Last year, consumers reported over 70,000 problems to Consuwijze. We also use tip-offs, signals, and leniency applications. The outcome of market scans, operational contacts on structural and ad hoc basis with key stakeholders like consumer organizations and TV consumer programs, the scanning of open sources like media, the internet, social media, trend watching, and economic intelligence by assessing the risks of infringements in certain markets on the basis of monitoring parameters that could indicate harmful behavior. Secondly, we know what is happening in the markets by asking external stakeholders for input. One of the steps we took in 2014 was to start an online consultation of our agenda and future sector priorities using social media like Twitter and Facebook. We also organized roundtables with stakeholders, with representatives from consumer and business associations. These roundtables, a strong tradition of the consumer side of ACM, were quite a success. Stakeholders are used by dealing with a single authority and presenting their problem from their perspective. It's only when you have an energy stakeholder sitting around a table with someone from the healthcare sector that they realize that our problem is not the only issue at stake, and that there are many perspectives to take into consideration. So we were able to create more understanding for the choices that we have to make when prioritizing. This was an interesting exercise and one that we will repeat. How do we then prioritize? Before I tell you more about the prioritization criteria we use, I should tell you that ACM does not handle individual consumer complaints. Our legislation only allows us to come into action if there are collective problems. So we are allowed, by Dutch law, to prioritize, to choose our battles. I know that is a different situation compared to other EU member states. We have a fixed set of prioritization criteria, which contains 3 main criteria that apply to the entire organization. Firstly, the harm that the problem causes for consumers. We will look at factors like the number of consumers that are affected, the financial harm involved, the irritation or loss of confidence, and the annual frequency. Secondly, we take into account the public interests that are at stake. For instance, the interest of society and politics, international aspects of the problem, and the importance of drawing a clear line in the sand or setting precedents. Thirdly, we make an estimation whether or not we are able to take action effectively and efficiently. When deciding each year's goals and priorities, we focus on the outcome and effects of our oversights on the markets. ACM's strategic management team, which includes the board members, the directors, and the chief economist, set the main goals and priorities during the year in 3 strategic sessions. These sessions make proposal for ACM's portfolio, our work plan, as well as the biannual agenda. The main themes for our organization for 2014-2015 are the online consumer, switching barriers in energy and healthcare, the willingness to invest in energy networks and telecom networks, healthcare consumers, entry to the banking industry, and government tenders. What are our learning points? So far, we have identified some points which we may improve our prioritization, and I shall deal with them briefly. In the first place, we have identified some blind spots in our intelligence system, which may cause us to miss important consumer problems. This has led us to tap into additional sources of information, such as youth and cultural minorities. Also, we will look into the possibilities of using a consumer panel to test the effects of certain behavior. Moreover, we will put more effort into predicting economic trends that will affect the context of consumer rights. And finally, we are looking for ways to encourage consumers to report issues that they would not easily report on, such as dating sites. In the second place, we have worked at some structural changes of our processes. For instance, we stimulate all ACM employees to become a valuable source of information by encouraging them to signal events that seem important for ACM. Also, we have defined top sources that are important sources for us, like the Advertisement Code Committee, the Dutch Foundation for Consumer Complaint Boards, and the National Fraud Help Desk. And we have made staff members responsible for the maintenance and contact. In the third place, we are in the process of building one single database for all intelligence signals and relevant information. And finally, we found out that many stakeholders prefer to submit their views on paper in a more traditional way, focused on their own isolated perspective at the end of the consultation process, rather than engage in issues online. Ladies and gentlemen, I would like now to conclude my contribution. The world around us is changing rapidly. New challenges are emerging. Some were already mentioned yesterday. I refer to the latest developments of consumers acting as producers of solar energy in the energy sector, consumers acting as traders, together with the rise of digital platforms like Airbnb and Uber. I could also mention the Internet of Things, the rapid growth of connected devices. Also the use of big data as a huge change, issues that we are going to explore further from different angles, such as the competition side as well as the consumer protection side. To monitor these developments and respond to them adequately, we need to set high standards for intelligence and prioritization. The challenge here is to identify not only the problems of today, but also the problems of tomorrow. We continuously work to further optimize our system. We are always willing to share and learn from this, as having the right information and making the right choices is essential for us if we want to achieve results for consumers that really matter. Thank you.
Well, thank you, Bernadette. I think it was very interesting for us all there to hear your experiences and advice from the Netherlands, from the ACM, particularly in terms of the issue of focus that you outlined, also details of your approach to prioritising problems, and I think we all found your learning points very valuable too. Now, I'd like to give the floor now to Teresa Moreira.
Good morning, everybody. And I myself would also take this opportunity to thank warmly the Latvian presidency for this invitation, for this organization, especially to BIBA, and for such a welcoming organization, if I can put it like this. I have a slightly different topic. As you can see, I'm going to talk about the review of the CPC regulation. And I have a number of slides, but since most of us are quite familiar with the CPC, I will probably just go a bit fast to get to my real points, which are what we can look for in the upcoming revision of the CPC regulation. So just to remind us all the level of ambition of EU consumer policy, which I think is extremely important, but at the same time, the fact that consumer policy is shared between the EU and member states, and this comes back to a word that was often mentioned yesterday, which was fragmentation. I suppose this is the beauty of the EU in a number of areas, but here it's obviously also posing some challenges for all of us to overcome together, hopefully. Also, the importance of enforcement. I have to say that I borrowed this quote: enforcement is about putting in practice the rights as European consumers have on paper, because I thought it was such a successful way of translating the importance of enforcement. I borrow this from the European Commission document that was prepared for the European Consumer Summit of 2013 that was devoted to enforcement. And so this really underlines the importance of enforcement and the need of stepping up enforcement, as it was mentioned in that European Consumer Summit. Actually, this summit also picked on one of the objectives of the European Consumer Agenda that was also already mentioned yesterday. And I would draw your attention for these 4 points that are mentioned, because I think that this really sets the agenda for the upcoming revision of the CPC regulation, meaning that we should and can, in my opinion, really improve enforcement capacities, develop stronger online capacities for enforcement, but also do something new, explore EU enforcement for these EU-level relevance infringements, and probably work closer with other partners, either other international organizations like ISPAN, for instance, but also third countries. So the CPC network is, in any case, quite recent. You know, it's Consumer Protection Cooperation network that will be working next year for 10 years already. So then we'll have, I believe, enough experience. And that only acts for infringements of collective nature. But in any case, that probably puts us in a different level when we talk about setting priorities, because, of course, from this point of view, enforcement also has a reactive approach, even though it is important to plan and set priorities for a better work. I also borrowed this data from the last Commission's report on the network. I think it's, in any case, quite impressive. Over 400 authorities involved. Again, I would underline here the fragmentation aspect I mentioned earlier, but a very big number of assistance requests, very successful internet sweeps. Actually, the data only refers to the end of 2013, but I would remind everybody that I believe that this year we're going to do our 9th annual internet sweep, and you see that from 2007, we were already very much focused on what we would call today the digital economy. So I think this was a very timely exercise. It is an extremely successful one. It's just something that we need probably to do either more often or on a wider scope, if I can put it like that, and probably also get increased visibility of this work. Other common activities, I won't bother you with that, but just to say that a number of interesting projects really directed, again, to the digital economy, so the internet enforcement capability, online investigation training. My own country, Portugal, we have benefited enormously from participating in these training actions and exchanging information and knowledge with other colleagues from other EU countries that are more experienced. So I also believe that is a very important part. And I will come to the common enforcement approaches. We've had this very, very successful in-app purchases in online games that I really thought gave an opportunity of showing consumers and businesses. And here, of course, I'm mentioning key industry players. We all know which companies I'm talking about, that there was a single network of enforcement consumer protection authorities in the EU that was taking action, and that together was stronger than any national authority individually concerned. So, getting to the point on the assessment and the future revision of the CPC regulation. Well, the CPC network has been under, I would say, close scrutiny because we have had these regular reports already. I would say that we can do a very positive assessment overall. There are very strong points, so this increased cooperation, very close and tight working relations and team building and learning experience, effective joint enforcement actions, even though I think the sweeps are probably the most visible part of this, and I think we can do more, and also this in-app purchases case as an illustration of common enforcement approaches. But there are also some weak points, and this is what I wanted also to address, because you saw that there is a very large number of authorities. Of course, in each EU member country, we have a different organization. And another feature that needs to be considered is this diversity of procedural law, namely in what concerns enforcement powers, because the fact that we have different tools to investigate, different decision powers, different sanctioning powers, would probably be much improved through some sort of harmonization. And also, from my point of view, the fact that not all consumers, not all European consumers are fully aware of the fact that we as a network can be stronger, I think is a weak point. And the same thing for businesses, because of course enforcement also has to take into consideration the fact that we as enforcers have credibility facing the companies, and that is also a point that I think we can improve. Now, talking about the review the review and the future revision of the CPC regulation. So there are a number of points that I think would relate to what has been highlighted previously: strengthening existing enforcement capacity and developing stronger online enforcement capacity. So there are a number of things that I think we as enforcers have already more or less agreed upon, even though the work has not started yet. And this would include also enhancing planning and priority setting, clearly improving the exchange of information, but also, again, doing more joint work and having national coordination, so single liaison officers have a stronger and probably more decisive role. But there are other, I would call them new issues that I think we should consider. Again, some of these issues were already highlighted during the European Consumer Summit of 2013. But I think here we really have an opportunity with the CPC regulation revision to step up enforcement. I'm talking about the address of what recently have been called widespread infringements, that is to say EU-level relevance infringements, because this could trigger not only an increased role for the European Commission, that could be conferred enforcement powers specifically in some areas, but it could also trigger the action of a best-placed national authority. I have to say that with my previous background in the competition area, one obviously tends to look to other enforcement cooperation networks within the EU, and I would like to mention briefly the European Competition Network. Of course, it's a completely different scenario, so to speak, because in competition we are only, between commas, talking about enforcing Articles 101 and 102 of the Treaty on the Functioning of the EU, while here we have this massive, wide and powerful EU consumer acquis. But the fact that there is procedural autonomy from member states has not so far prevented this European competition network of being extremely successful, and it was created only in 2004, so it's also a recent network, but also a very successful one. So I think we could consider this, and I think we could really make a significant difference if we were able to tackle with stronger means, with a quicker response, serious infringements of consumer law, let's say with a European dimension, to copy a bit the reference of the competition network. Also, I think we need to expand international cooperation. I mentioned that before. And probably just engage even more with ECC's network that are also here present. I'm coming to an end. I think this is a unique opportunity also to make sure that we are able not only to fully enforce the very important acquis of EU consumer law, and with that further protecting European consumers, but also really reinforcing also our work together as authorities. I mentioned that it is very important to keep up with market and societal changes so that we have the knowledge, the tools, and the resources necessary to act against these infringements. Of course, we all have some budget constraints nowadays, and that is obviously challenging. A final word just to mention redress and the possible consideration of involvement of other stakeholders. I think we haven't had yet an opportunity to really explore this issue, but of course I think that the future revision of the CPC regulation will provide us this opportunity. Thank you.
Thank you, Teresa. I think it was interesting for all of us to hear about the CPC regulation, the upcoming review, and your suggestions about concrete action to enhance cooperation and then enforcement as a result. Now, I'd like to hand the floor now to Baiba Vitalina. So the floor is yours.
Yeah, thank you very much. Good morning, everyone. I hope you are very excited after last night. I enjoyed it very much. Thank you for your company. But now a little bit about more serious things than yesterday night. I will be a little bit different from other speakers, I think, mostly today, because my theme is about product safety. Because Latvian Consumer Rights Protection Center, we are not joined with competition issues, but we are joined with product safety issues. So we are also main market surveillance institution in Latvia. What I will talk about, I think that in European Union we can be proud of our legislation in product safety, and the most issues we have left, I think, are related more with enforcement. Of course, everybody waits for the product safety package to be adopted, but even without it, I think our legislation is quite good, and only thing we have to do is just work. I will give you today a little background about Latvia, how we organized our market surveillance here, and I will talk about some issues we see in product safety and product conformity. As you may know, Latvia is a small country with just about 2 million inhabitants. But now we are a member state of European Union. We joined in 2004. We very much wanted, as you see, to come to our big sister, and now we are here. But it hasn't been an easy way for us. At the beginning, you could think just you write down legislation and that's it. But to be honest, if we speak about product safety and conformity of the products, it was big changes in thinking of Latvian people when we introduced this legislation. We've had to change from planning economy on pre-market certification system to producer liability, and sometimes maybe we forgot that freedom comes with responsibility, that we have tasks. Very often we hear that our entrepreneurs think that it's free market, we do not have to organize any certifications, we do not need documents, but they forget that they are responsible for product safety and product conformity. How we introduced the system, as I mentioned already, the implementation of directives, it was the easiest part of everything. I think the most difficult is to change our thinking of economic operators who have to now not only find the document to show the market surveillance institutions, but they have to also care about the safety and conformity of the products. Also for market surveillance, I think I will not lie if I will say that in Latvia there was no market surveillance before we prepared for the getting European Union member states. Most our work was related with controlling prices in the shops, maybe illegal alcohol and something like that, but not really safety of products, conformity of products, because it was considered that mandatory standards and they have to be observed, and so no market surveillance is needed. And of course we had many problems like need for knowledge and specialized inspectors and lack of laboratories. And we are very grateful to our friends from other member states which have very much helped us on this in product safety and also of course on other consumer protection matters. Concerning the issue of product safety, I think we have to remember that although Karina told yesterday that it's fundamental rights of consumers, but we still see that even if it's fundamental, it's not always the case. We see more notification in RAPEX system every year. So last year you can see the data here, more than 2,000 in Europe. Also, injuries related to products are quite often, and you can see here the data about that. I think this is something we should care about. Here you can see results of Consumer Protection Center's market surveillance, and I was just mentioned that the blue one is how much we have controlled, and the red one is how much we have found non-conforming products. So you can see it's more than 50% last year. Import is one of our priorities very much, because you all know that it's the easiest way how to control the products, and we have very good cooperation with customs, which I will mention later as well. We see as well here that we find quite many non-conformities also on the borders. And new thing we do now is we also started to test products and to take for testing on the border, not always in the market. So we have also found several dangerous products testing on the market, so really not allowing them afterwards to come in our country. I wanted also to mention such thing as safety of services, which is not European Union regulated area. But I think that if we would look about statistics of accidents, at least in Latvia, we have quite many accidents related with services. And we are quite lucky because we have this possibility to regulate it, and we have a law on product and services safety law. It's quite similar to the European Union GPSD requirements. And what we do about that, for example, you could maybe laugh. I showed Latvian picture because it's, as you got to know yesterday night, the highest point of Latvia is 311 or 12, it depends who says. But we have downhill skiing possibilities here in Latvia. And you could think it's not a big problem, but to be honest, there are quite many accidents on those small places, maybe because there are small places, but many people there, so accident risks are even sometimes more, maybe different, but more. So we have prepared guidelines on skiing services, and I think it has worked very well, because afterwards, entrepreneurs who know what we require from them, they do that. Another example, I wanted to show is, I don't know how well you see, but it's from Soviet times. We still have in our gardens such kind of swings which are considered in Europe dangerous for kids. And they are still in use in Latvia, and we require to take them away. But the interesting thing is that our consumers, they are angry about that because they like it. Consumers not always understand the risks until they have the accident with their own child. And I specifically wanted to mention this aspect, this consumer attitude to many things, and also to their responsibility to this safety issue. And also from complaints in Consumer Center, we can see that there are more complaints on quality of shoes, or broken electric products or so on, but we quite rare get information about accidents and about safety of products. So it shows that maybe consumers do not understand fully this subject. And also if we see what happens with our consumers, how safely they live, I can see that we don't like to wear helmets not in skiing slopes, no on bicycles. We are quite brave. We think nothing will happen to us. And changes in thinking are quite slow. Only recently we see that in these skiing slopes, at least kids have helmets. So you can change it. Another thing is that our consumers do not require redress for such kind of things. For example, we had a few years ago a very serious accident with the 11-year-old boy on the skiing slope. And it was fault of, even our center said it was fault of entrepreneur, but they didn't want to request anything. They said you have to do something about the problem. That was a good thing, of course, but they don't require money from them. But I think that you should do, it's your responsibility as consumer, because it's the only thing which can change behavior of entrepreneur if he has to pay in such cases. We have now two court cases. I wanted to show this picture with gas cylinders, which are very popular in Latvia. Still we use it, and unfortunately, from time to time, they are blowing up, and there are very bad situations afterwards. There are many damages, and we have now two cases when entrepreneurs have been in the court, and the court has decided in favor of consumer according to the law on product and liability of producer. Product liability, sorry. In general, some problems which we see, I will not mention everything, but one of them is, I don't think always economic operators do some bad things because they want to. They also very much lack information, what's the real requirements for the product. It's quite difficult. In this one thing, we also work very much. We organize seminars for entrepreneurs. We try to prepare information, but I think it's what where we can do more. Also, the problem we have seen is that importers, which see what we import here in Latvia, they cannot import here in Latvia. They switch countries and try to do that in Estonia or Lithuania, for example. And of course, online is one. I will show some aspects as well. This is just example from, I think Netherlands has prepared this homepage for entrepreneurs, which I think can use other entrepreneurs in other countries as well, which gives you information what are requirements for products importing in European Union. About online a little bit, I will not talk about everything of this, but we have worked on some study on energy labeling of some products, which where law specifies that it has to be on the in the internet. And what we found out is that for full information is available just for 12% of TVs, 11% of washing machines, and 0% for refrigerators. So this is the case where you have the law, but it's not really working in the practice. And why I mentioned it especially is that according to the Consumer Directive, you have to show on the internet main characteristics of the products, as you may see, to the extent appropriate to the medium and to the goods or services. But what does it mean? For example, for toys, do you have to show their age limits? Do you have to show warnings? We have an interesting project this year about construction products, where information of performance indicators is very important. But there are shops where you cannot find anything about construction products. So how can you buy it if you don't know what are the performance indicators of it? That's, I think, something we should do. And now for working together, cooperation is very important. I think yesterday also a business representative mentioned some cases, but we also see it that sometimes it's not always, we don't always think the same. Is it the toy, for example? We had such case in Europe. And also, do we require the same measures? Sometimes in Latvia, we, for example, take out of the market product, but in other countries, they can take in other. For example, ask for testing and certification or something like that. I think that's cooperation is key here. That's just an example. I wanted to stress that we have first Baltic States project with our customs and market surveillance authorities, because we saw that really products from Latvia are going then through Estonia or Lithuania in our markets anyway, because we have different priorities. So this year we had this project, and I think it was very successful. And here I wanted to show that, for example, our consumer ECC, with our center together, we prepared such a game for consumers, and I think that's good too. We should do next times as well. You can see here, for example, we teach about safety in ski slopes there as well. And now very shortly, just my conclusions that I think that legislation is quite good, but of course we have to go further on. It's very important that we focus at the source. We have to work with producers, educate them. We have to make system audits, which I think we also will talk today about as well. We need closer cooperation. We have to prioritize as well in this area, not only in the consumer enforcement. And I think the most from my side is that I think the consumer awareness raising is very important, because consumers are those who decide which product to buy, which product will survive in the market. So that's very important. Thank you.
So thank you, Baiba. I think it was, again, interesting for all of us to hear some specific concrete examples there of Latvia's experience, both before EU accession, during, and also after, in terms of improving enforcement of product safety. Now, I'd like to open the floor now to our final speaker, Martin, please.
Well, ladies and gentlemen, it's a great honor to address you today on behalf of the European Economic and Social Committee. I would like to start to congratulate the Latvian Presidency, and in particular the Latvian Consumer Rights Protection Center, for organizing this event. Yesterday's discussion was thought-provoking. I hope today's discussion will be equally exciting. So many thanks to the organizers for inviting us to this conference. For those who are not familiar with the European Economic and Social Committee, a brief introduction. We are a consultative body of the European Union, which represents organized civil society. Our purpose is to deliver opinions on the proposals, legislative proposals, by other European institutions like the Council, the Parliament, and the Commission. The committee can also exercise its right of initiative to draw up opinions on issues that it believes to be a priority. One of these issues the committee is currently working on is an evaluation of European Commission stakeholders consultation. The value of the opinions drawn up by the committee lies in its composition. 353 members represent the 28 countries of the Union, forming three groups: employers, workers, and other interests groups that have one thing in common: they are not a social partner. Consumer associations are amongst those other groups. Consumer policy is and always has been very high on the committee's list of priorities. It delivered a large number of opinions on consumer-related topics and also organized various events dedicated to consumers. Let me just give you two examples. We organize every day the European Consumer Day, mid-March. It was held this year in Brussels. And we also have another event coming up on the 21st of May here in Riga. We organize together with the Latvian National Consumer Organization a conference, Empowered Consumers in the Energy Market. You will find more information on that conference on our website and the website of the Latvian National Consumer Organization. But let me use the opportunity to invite each and every one of you here to join us there too. Let me get back to the topic of my address: better regulation and the impact of refit on consumer rights. I think we all agree that EU legislation is essential for achieving the objectives of the EU Treaty to protect health and safety, to maintain a level playing field for businesses, to ensure competition, and to counter market failures. It also contributes to sustainable and inclusive growth and decent jobs. The economic situation has focused attention on the costs of EU regulation and challenges of implementing laws. Strained administrations face difficulty in keeping up with transposition and application of EU legislation, Businesses and citizens, I've read research recently that 40% of European citizens believe so, raise concerns about the complexity and the administrative weight of laws. To respond to those concerns, the European Commission has introduced a better regulation policy, which aims at ensuring that public policy objectives and the benefits of EU policy and legislation are achieved at minimum costs. One of the pillars of the better regulation policy is the European Commission's Regulatory Fitness and Performance Programme, REFIT. With REFIT, the Commission intends to make EU law more fit for purpose, to simplify and reduce regulatory costs while maintaining the benefits. Our committee supports the general objectives of the Commission's REFIT programme to cut red tape and constraints on small, medium-sized and micro-enterprises in the public. But in principle, the Commission should focus on quality of legislation rather than on quantity. When I look at the facts and figures of the Smart Regulation website, I see that almost 200 REFIT actions are being implemented. More than 6,100 legal acts have been repealed since 2005. And in 2014 alone, 53 legislative proposals have been withdrawn. Would those 74% of Europeans who believe that the EU generates too much red tape might actually be right? Or has the Commission gone too far in those fitness checks? Good legislation does not mean reducing it to the absolute minimum. So apart from the costs of regulations, there are also costs when there is a lack of regulation or on deregulation. Those costs also have to be taken into account. That hasn't happened. And less regulation does not automatically equal better or smart regulation. Smart regulation gives no dispensations from the obligation to comply with the regulations on protecting the public, the consumers and the workers, and with gender equality and environmental standards. In the Commission's impact assessment, there's too much attention given to competitiveness and too little to social and environmental concerns. The EESC was and still is advocating the think small first principle, but exemption clauses for SMEs have their limits. When it comes to standards in relation to health and safety, to the environment, or to social issues of citizens, employers and consumers, it must be ensured that these apply equally to all businesses, whether they are small SMEs or large corporations. Regulations in respect of protecting employees and consumers must not be undermined or abolished under the guise of reducing administrative burdens. In fact, exempting SMEs from consumer and environmental protection regulations may ultimately harm those businesses. The ex post analysis of the Commission is the ex post analysis the Commission is proposing should be conducted after a certain period of time has elapsed. In effect, ex post analysis is only meaningful if a certain number of years have elapsed between the deadline for the transposition of a regulation into law and the ex post analysis in question. Otherwise, refit would become a source of permanent legal uncertainty for both the public and businesses. Our committee will be launching its own ex post evaluation of EU legislation to complement those performed by the European Commission and the European Parliament. Our aim is to extensively involve civil society organizations in this exercise, including, of course, consumer organizations. Another aspect of the REFIT program that is particularly important for consumers is the consultation process. Consultation is the cornerstone of legislative proposals that are of good quality, are based on robust evidence, and have a massive support in civil society. But although the Commission stresses the key role of stakeholders' consultations in the process, their outcomes are not always taken into account. Consumer organizations, together with other civil society organizations, social partners, and intermediate organizations concerned, should be given absolute priority in public consultations. Consulting individuals directly, either be they consumers or SMEs, has proven to be ineffective, anecdotal, and unrepresentative. What our committee suggests is that these consultations could be given a more structured institutional and representative foundation by taking advantage of the resources and the representative consultative bodies that already exist, both at EU and national levels, and if appropriate or necessary, other bodies of this kind could be created. I want to leave enough time for discussion, so let me conclude by stressing one thing. Juncker's European Commission wants to be big on the big things. As far as the EESC is concerned, safe consumers who have sound rights in both the digital and the real world are a big thing. I hope the Commission's actions, when continuing its refit program, will be based on that same conviction. Thank you for your attention.
Thank you very much, Martin. I think we're all interested there to hear the European Economic and Social Committee's view on refit and how it impacts on consumer policy. And we picked up on your key message there that the Commission has to focus on quality and not quantity in refit. Okay, now I've already received a number of questions from the audience, and I can see I have one or two more pending as well. So if you'll permit me, I'll take two questions that I've already received, and then I'll open the floor for you, sir, as well. Okay? So my first question is specifically for Teresa, but also for the rest of the panel as well. And the question is as follows. Is there sufficient cooperation, in your opinion, between the CPC network and consumer organisations which enforce consumer rights?
Thank you. Thank you very much, and thank you for that question. Well, quite frankly, I don't think that consumer organizations, if I understood the question correctly, play a major role, or even a role, if I can put it, in an enforcement cooperation network that gathers national enforcement authorities. I mentioned a possible role or an increased role or some consideration to a more important role of consumer organizations because, of course, in some member countries, to my knowledge, consumer organizations not only convey important information to the enforcers, as they, for instance, play a very important role in redress. And I don't think one can separate enforcement from redress. I think enforcement is extremely important, and also redress, as actually Bible also mentioned as a general point. So that is also important, and that is also a subject that the European Commission has been addressing for the past 2 years or so with a recommendation that was approved in 2013. So I think that the future revision of the CPC regulation should provide us also an opportunity to reflect on the role that consumer organizations can play, and I look forward for future engagement from that part. Thank you.
Thank you. And yes, indeed, Bernadette.
Yes, I fully agree with Teresa, and I would like to stress, for instance, in the Netherlands, we have a very strong consumer organization with a much longer history and a much more impressive reputation than we have as consumer authority, because the consumer organization, I think, is over 50 or 60 years old, and we are only, if you include the consumer authority and now the ACM, we only exist around 10 years now. So we think it's very important to give an important role to the what we call the private fundament also in our work. So.
Okay, thank you very much. I'd like to open up the floor now for two questions which are pending, and I see two more as well. So I'll work around in the order they've come up. Please, the floor is yours. But before I give you the floor, can I reiterate to all of you to fit in all of your questions in our time frame? Can I please ask you to limit yourself to a single question only, rather than multiple questions, please? The floor is yours. We have a microphone for the gentleman, please. Thank you. I'll bring you in second, okay?
Yeah, Bob Schmitz again from the Luxembourg Consumer Union. Actually, I want to challenge with one question then Teresa, when she says actually that the European Competition Network will be very different because they have only one or two treaty articles to apply. if we take the longest-standing authority, which has actually competition and consumer protection together, it's the Italian. And I know whether he's still in the room. They actually have shown that actually by focusing in particular, take the Apple case and now TripAdvisor, on one piece, which is the Unfair Commercial Practices Directive, and apply it in the same way with a real argued decision, which leads to fines or even corrective measures. So it's like the competition decision. On that one, actually, we, the consumer organizations, can pick up and use it in the pan-European way. So I believe, therefore, my claim would be, nothing to say about safety, that's something else. But on the online, particularly on the unfair practices, if we really concentrate also that one, bottom up from the authorities, including if the Dutch could set a precedent, I'm not aware of in this kind of decision you would set under the Unfair Commercial Practice Directive, we could pick up in other countries. I think that would really help very much. And last to finish, because when you mentioned the online app games, actually I can't remember that there were press releases, but where is the final report? Is there any final report put out by the European Commission? Otherwise, we have no learning. These are just, statements, and that's completely different from having fully argued decisions like the Italian authority sets regularly precedents. That's the way to, in my view, is to work forward. Thank you.
Okay, thank you. Teresa, would you like to comment on those points raised?
Sorry, yeah. I don't want to monopolize the debate.
Don't worry.
Okay. Well, thank you very much for that comment. I actually think that the Italian competition authority has done a very successful job enforcing EU consumer law. But as I mentioned, as member states, we have different organizations, and we are entitled, and I'm quite happy that we are entitled, different ways of organizing our institutional framework for consumer policy. I will just mention this. For instance, in my country, as far as the CPC network is concerned, my own Consumer Director-General is the SLO, but we are a total, in a country of 10 million people, 13 different authorities within the CPC network. Of course, that is more challenging than, for instance, in France, and I'm looking at Natalie because I realize it's a much bigger country with a smaller number of authorities. So there are a number of challenges. But, what I mentioned when I talked about the European Competition Network was that, for me, there is really room for learning from what the Commission has called stepped-up enforcement, in the fact that we should consider, and we have supported that the European Commission be given a specific role as an enforcer, but also that, I know that a number of organizations disagree with that, but also that we agree on rules that could trigger the best placed national authorities to act on behalf of us all, so to speak. Of course, we still need to agree on that, but I think that would really increase also the efficiency of EU enforcement. On the in-app purchase cases, to my knowledge, there have been a number of press releases, and there has been a second round of commitments, actually, that are posted, I am sure, in the DG Just Consumer Policy website of the European Commission. But I take the point. I think that for me, businesses and consumers are not fully aware of the fact that there is this enforcement cooperation network. And I think we also need to work on that. Thank you.
Okay, do we have anyone else on the panel that would like to add anything there? Okay, in which case, please, your question for the panel.
Thank you very much. I'm a member of the European Economic and Social Committee, but also an advisor to the Fraud Help Desk in the Netherlands, which is a public-private initiative to combat fraud regarding businesses and consumers. I would like to have a question relating to the issue Mrs. van Buchem mentioned, dating fraud, because we get in the Netherlands around 300 cases a year concerning dating fraud, with a financial damage of 3 million euro, but what is even more important, the emotional damage. There are even cases of self-murders in the Netherlands. This issue is being considered in a worldwide working group where, among others, the FBI, Interpol, Australia, and the EU is participating. And my question would be very concrete about dating fraud. What is being done on the EU level in this field, especially as it is 100% digital, and it is highly international, and if we don't work together on this issue among member countries, there will be no solutions. Thank you very much.
Okay, Bernadette, so could I ask you to address that question of what is being done on EU level, please?
I have to be sorry, but I don't know what are exact initiatives on EU level. What I know on what we do in the Netherlands is when there's really fraud, and we have signals of that. We work closely together with the police, and I think that will happen on EU level as well. And what we do as national consumer protection agency is also inform consumers and make them aware what can happen. So to give a lot of information and also instruments to realize if will be misabuse of their data. But I don't know exactly that's not my area, what's happening on EU level, but maybe one of my... I think maybe the Commission knows.
Okay.
Yeah, but I think I can't solve it here.
Indeed, indeed. Well, thank you,
Bernadette.
Bernadette.
Signal, but yeah.
Thank you, Bernadette, for your intervention from the Netherlands perspective on that. Okay, I think now we'll move on, if you'll allow us, to the other questions which are pending in the room. I think we have 3 waiting now in the queue. So can I bring you in, please, for your question?
The association
I'd invite anybody in the audience that would also need interpretation to take it now, please. Okay. I'm going to need one. I do need one, yes, thank you. It's okay. Shall I go and get another one, perhaps? Oh, we're okay. Okay, we've all got one. Great. Oh, of course, Barbie, you don't need one, do you? Right. It's channel 1. Channel 1 you need.
Thank you for this possibility to express myself in Latvian. Today I'm very much interested in product safety. I believe I will make use of this question when I work in the panel, and I will speak as an ordinary consumer. For the Latvian consumer, we see that there are very many complaints about quality of cars, and we know that we have a very high level and percentage of car accidents, and we also have draw the conclusion that something is wrong with the quality of these cars. And if we can, I also drive irrespective of my gray hair. And also, I had an accident with my car and it was a question of car quality, and I, through the European Consumer Information Network, I submitted my complaint, and I failed. I tried to get in touch with the factory in a digital way online, and that was a failure too. And then I wrote a complaint only after the written information. It took the correspondence took half a year. I got compensation, redress about the non-compliance of the quality of the car to the standards. I believe that the European Commission should pay attention to this issue. There are very many questions with car safety, and as an ordinary consumer, I realize that the ordinary consumer cannot solve his or her needs and problem in such a simple way. We drive, all of us, starting with the age of 16. Thank you very much.
Okay, Baiba, can I direct that one towards you from a Latvian perspective to just summarize the points made?
Yes.
That, if I can just briefly, that it appears then that Latvian consumers have many complaints about quality of cars. There's a disproportionately high level of accidents has been claimed, and the procedure from an individual consumer's perspective can be very difficult to deal with those complaints.
Yes, I will answer in English, sorry, because sorry that you have had this experience, that it was not successful to get your redress fast. I cannot confirm that in the Consumer Rights Protection Center we have many complaints about unsafe or non-conforming cars, especially new ones. If we have some complaints, that would be mostly about used cars. I think but anyway, this problem is, I think, very important. And more, I would say, even for the point of view that we need better redress for consumers. And we can admit that in Latvia that is a problem, and we are now very much working on the new implementation of new directive of alternative dispute resolution. So we hope that when this will be implemented, and of course we will continue our work with the consumer information and business information, so they know that they have to comply with these rules, that this situation will get better.
Okay, thank you very much. Now, can I just clarify the other members of the audience that still have pending questions, please? I noted another few before yourself here and also here. So can I bring you in now with your question for the panel, please? Do we have a microphone, please? Thank you.
Can I ask a question? Since I've been waiting for some time.
Oh, can I bring you in after this lady? There will be sufficient time for your question as well, don't worry. Let's check.
Okay, thank you. My name is Ida Masenga. I'm a legal advisor for international affairs at the Swedish Consumer Agency. I have a question for the Director-General, for Teresa Moreira. I have been dabbling with the consumer law since 2010, more or less, but I originally trained as a competition lawyer, so that's why I thought the parallel you made with the European Competition Network was quite interesting, in particular from the aspect of giving increased enforcement powers to the Commission, if I understood you correctly. When I was training to become a competition lawyer, I was taught that the reasons for why the Commission has enforcement powers when it comes to competition is because the articles in the treaty are directly addressed to companies when it comes to competition law. However, when you look at the articles in the treaty, which are the legal base for secondary legislation for consumer protection, they are directed to the member states, which is why the enforcement powers lies with the member states. Now, assuming that there is no pending revision of the treaty in the near future, I haven't heard about one at least, that could possibly leave us with trying to modify the treaty through secondary legislation. It has happened before, and then you always run the risk of having a member state actually reacting upon the legality of such a measure. And usually the European Court of Justice doesn't look upon it with favorable eyes, according to previous case law at least. So I wonder, how do you foresee this in practice? Do you have any ideas? Would it perhaps be more like the Commission taking a more active role through infringement proceedings or other kinds of pressure on member states to act when they don't ask? Or have you had any ideas around this, how this would look in practice? Thank you.
So Teresa, would you like to respond to that one?
Thank you very much for the question. Obviously it's a very good point, and you're absolutely right about the direct effect of Articles 101 and 102 of the treaty, which does not happen, which does not translate into consumer protection. But I would only just say this: in any case, directives of maximum harmonization also don't entail directly from the treaty as far as consumer law is concerned, and yet we have seen a number of them. So I think secondary legislation has, let's say, a different dynamic, so to speak. So I would not really see any major legal obstacle. On the other hand, there may be an obstacle because member states apparently are not necessarily willing to grant the European Commission that kind of power, and that is a completely different thing, and that is a bit of a conclusion I take from the public consultation that was held, I believe, 2 years ago, and when you go through the answers, you see that I believe most national public authorities were not in favor of actually conferring the European Commission that kind of power. I mentioned that because we supported actually that, and so we stick, so to speak, with that proposal, but we realize that there may be more clever ways of going around it, and that's also why I mentioned the European Competition Network, because there are very, I believe, workable rules on division of work within the European Competition Network, and I found that very interesting. That's why I mentioned triggering the best place authority, for instance, national authority, I mean, to act on behalf of the EU when we are dealing with a EU level of relevant infringement, what we now call widespread infringements. That would be much economic, much more efficient, and again, it would underline the cooperation work that we have been doing. Thanks.
Thank you, Teresa. Now, I have 3 pending questions from the audience now. The intention is to field all 3 of them. We have 1, 2, and 3 before we break and take a short break. So please, over to you for your question.
Thank you. Okay, thank you. My name is Baiba Miltovića. I'm representing Latvian National Association for Consumer Protection. First of all, I would like to thank organizers for a possibility from our civil society to be widely represented here. So it's a first comment, thank you. And the second, thank also speakers for very good presentations. I found them very interesting. Well, I would like to turn my question to the Consumer Protection Authority in Latvia, of course. And if I'm not mistaken, in the presentation you showed in the table the number of non-conformity products is increasing. If we see year by year, would you comment your observations as regards product safety culture by industry side? Is it changing? Do we have any hope that in the future these numbers will be not so rapidly growing? Thank you.
So please, Barbara.
Yeah, thank you for your question. I think when you look at such kind of data as were shown, you always have to think how to interpret them. And I wouldn't think that if you have more and more non-safe products or non-conformities, it always means that you have more unsafe products on the market. And our conclusion at the moment is that our center has done very much to train our people in our office that they can really look for the risky products, and that we really target our activities. So that would be the one of the reasons why we find more and more non-conformities. But of course you cannot find them if they are not on the market. So of course there is another angle, which is business behavior. My personal opinion is that it's getting better now, that of course we have done very much for businesses to be informed about their duties, responsibilities, what they have to do. But there is still much work to be done because the products are so different, the requirements are so different that there is, it's really a big job ahead of us to do it anyway. So that I think.
Thank you, Baiba. I believe we have a question now over here, is that correct? Yes.
I'm happy to wait until the end. It's Carina Törnblom from the Commission. I don't really have a question. I thought there were some issues popping up directed to the Commission. So if I can help at the end and not take the time.
Indeed, I think that would be a good idea. If everybody agrees, I'll bring you in to comment on those particular points at the end. So I believe now we have one more question over here.
Thank you. Guido Lobrano from Business Europe. I would like to go back to the issue of the possibility of moving consumer enforcement to the Commission and the parallel with competition, the competition system. I wonder why some would think that might be a better solution, because the main reason why competition enforcement is in the hands of the Commission is because many competition infringements are actually cross-border. And the Commission only has competencies for cross-border infringements, while national infringements are competence of the national competition authorities. In a similar debate on data protection, actually, member states fiercely opposed the idea of having some sort of transnational enforcement system, and they strongly advised to keep national data protection authorities in charge of infringements for the principle of proximity. So consumer citizens are closer to the national authority. It's the authority with which they can better talk to and discuss, and if there is a willingness to challenge the decision in court, they can do it in a national court. Companies in antitrust breaches, when decisions are taken by the Commission, have to go to Luxembourg to challenge them. So I'm just wondering, why would such a system be better for consumers?
Can I just clarify which panel member you'd like to address your question to, please?
Teresa. Thank you.
Okay. So, Teresa, would you like to comment on that particular set of points?
Yes, but I'll then hand the floor also to Bernadette, I think. No, it is an interesting point that you raised, but let me clarify what I suggested first. For us, the idea was never to transfer enforcement competence to the European Commission. I'm very happy with our own enforcement responsibilities. We just want to improve enforcement, and of course we are concerned because we are in an internal market. And also following up on what I said to Ida, of course the challenge is, how do we have a full functioning internal market if we as member states stick to our own national enforcement capacities, priorities, organizations. And of course, as all member states representatives here, I also want to keep our own organization and the possibility of adopting more protective measures as far as consumer policy is concerned. But that raises a number of issues, and especially when you concern digital economy. I mean, you no longer can stick to your own national market or border, because that's long gone. So we have to how can I put it, look forward, fast forward looking approach, and work together trying to find more effective ways. So I was not suggesting again that there was some transfer of responsibilities, but a number of times during the past years, an increased role of the European Commission has been often mentioned by not only national enforcement authorities, but other stakeholders. So I think that could be considered. Again, what I think is that there are cases where you have this, what are now called widespread infringements, being serious infringements of clear EU relevance. For that, probably we can either increase coordination and jointly enforced. And again, it was not a typical enforcement case, but the in-app purchases case I think, makes a strong case for further joint common enforcement actions, or we could just appoint the best placed authority. I mean, personally and from a national perspective, we could very well live with that kind of solution if that is agreed by, with other national authorities. And when we appoint the best placed authority, that could well also include some enforcement role of the European Commission. On the details, we still have to think about it and discuss it, but I think that would clearly improve also the work of the CPC network. Thank you.
Yeah, I think I fully agree with your answer, Teresa, so I don't have to comment much more on it, but I also would like to stress that there are of course, also in the consumer field, problems with EU relevance, and then it's more effective and more efficiently to cooperate better with each other, and also to have a greater role for the European Commission. So, and you already gave the example that, especially in the digital economy, then there are many also cross-border problems. So, I fully agree with the answer already given, so I won't repeat. So, because I can imagine that people are longing for coffee now. So.
Okay, that's very considerate of you there, Bernadette. I think with a view also to providing you all with a break before we go into the 3 parallel sessions, can I hand the floor now to a representative from the European Commission just to comment finally on a number of the issues that have been raised?
Let's start with the last one. So maybe I should stand up because I don't see everyone who has been speaking. Contrary to everyone's belief, we are absolutely not power hungry in the Commission, and certainly not in the consumer policy area, but we do look at this CPC review very, very seriously. First of all, there is not a question of undermining or robbing the national authorities of anything whatsoever. We would like to have them for them to have even more powers in certain cases, because the mandates are very different across Europe. So first of all, the national authorities should be as strong as possible, and the national network of enforcement should be as strong as possible, including cooperation with other stakeholders such as consumer associations, roundtables and stakeholder consultations with business, everything that can be done at national level as best as possible, we are all in favor of. Hence, even the start of the network to exchange knowledge and information and experience, and then stepping it up to doing actions together. Then, the consultation about the Commission's role and the future of the regulation and the network, as we see it, because of course we should compare to what is prevalent in other policy areas, but we must look at what is the development in our policy area and why is that, and what do we need to address. And I think, first of all, it's about resources. So we look at the national resources, we look at the Commission resources, and already there, I think we all understand that we can't manage all this on our own. If the Commission would do it on its own, or one member state would do it on its own, it wouldn't work, if you look at the cross-border development that we have. So we are interested in how can we improve, with the help of any kind of change role of the Commission, the cross-border sort of enforcement that we need to do. So it's about resource efficiency. So can individual member states take on their shoulders to tackle these problems individually? I don't think so in the long run, because everyone is under cuts of economy, etc. So we have to see how can we do it together. And the Commission could play a role. We are completely open to what kind of role, of course, but I think there is a role. And also we have to look at efficiency. So how quickly can we act when we act collectively or together? Who should take the lead? And I think can very well be an individual country, but then we have to know that that country, or if we build a system, that individual countries will have these resources long term, and you know, who can guarantee that? Then the the third issue, I think, is also conflicts of interest, because it's very difficult, and I think we all can understand that for an individual country to tackle important businesses that are placed in their country, it's a big ask, okay? So I'll stop there, but rest assured that we have a completely open mind. There is a serious impact assessment going on to just find out what would be the ideal situation and all different alternatives as you do in an impact assessment. For me, this is important. I took the floor on this because I can't, unfortunately, see my colleague Angelo Rieko, who is in charge from the unit of doing the impact assessment work. But he will be in one of the seminars in the, that follow shortly, so please ask him more. But do not worry that the Commission is trying to take a role that it shouldn't have. But we have to look at the development in the market. We have to look of economies of scale and the best possible and efficient attack on things that really needs to be addressed. Not everything, obviously. Then I think also on the consumer organization issue, I have seen now a development recently where it appears much easier for vertical, specialized enforcement authorities to work with consumer associations because they have a limited field. So we have the energy regulators, for instance, are working together with BEUC to see how there can be a good collaboration. I must say for the consumer authorities, and also given the stage in which the CPC network itself is in, I think it's first things first. This is how I understand the message from the authorities. But it doesn't mean that there shouldn't be a cooperation. And that has to be established. How can information be exchanged? At what level? What different roles can the actors play? And of course, consumer associations should be a big part of a collaboration. First of all nationally, but also at European level at some point. But that needs to be defined, and I don't think there is any opposition about doing it. It's just much more complex when you are responsible for everything. This is the problem. But it definitely needs to be done. And also, last but not least, and then I'll stop because you will kill me if you don't get your coffee, I'm sure, the refit and the impact assessment that was brought up by the Economic and Social Committee. It's very, very important, I think, to understand that for internally in the Commission, when we speak about refit, and that includes us in the consumer policy field, we talk about quality. Quality is everything. So when you look at examples of refit, we need to look at, for instance, for the future, one quite recent directive, unfair commercial practices. We will look, is this directive looking as it should given the market developments? Do we need to improve, strengthen, delete? Do we need to change how we tackle things? One very important question that I think we will see is about information requirements. Do we need all the requirements, or are they correctly formulated? Because if we ask for too much, it doesn't always help consumers, and I think we all know that. We will talk about this in a few minutes. And also when it comes to impact assessment, thanks to our fact base, knowledge base, all our studies, research, scoreboards, everything, we feed in, trust me, from the consumer side into impact assessment of everything that other services in the Commission do. And without this fact base that we are all now paying for together, we would be in a very bad position in those situations. But I totally agree that it should not only be about competitiveness that is assessed in impact assessment, but lots of other dimensions, including impacts on consumers. And we at least provide that part thanks to the research that is done. Thank you very much, and sorry for taking your time.
Right, well, thank you to everybody, the panel and all the audience members, for I think was a productive discussion following the interventions there. Now, I'd like to spend about 60 seconds of your time now giving you some need-to-know information about the parallel sessions. Specifically, where do you meet to go to your parallel session? So do listen carefully, please. So for the first session, challenges for enforcing product safety rules in the digital era, the meeting point is at the registration desks outside this room at 11:05, please. And it's taking place on the first floor in the Arbava Hall. But your meeting point, 11:05, outside this room, please, the registration desks. The second session, Problematic Consumer Markets and the Way Forward, Making More Effective Enforcement and Redress, that is in this room. In this room. And the third of the parallel sessions, Consumer Confidence and Empowerment, that is on the first floor in the Venter Hall, and your meeting point is the lobby area of the hotel, again at 11:05. So you now have yourselves a 10-minute break for that coffee. Thank you very much.